Well, thanks very much, Eric, and it's a great pleasure to be here today, always with any event that UWS and the Whitlam Institute are involved with. And I would have to say, though, that I have been given a daunting brief in my introduction. I've been asked to do the simple task of summarise or point to the high points of 14 years of lawmaking in the field of anti-terrorism laws, running across tens of thousands of pages, and I've got 10 minutes to do that in, so I'll do my best. Now, the starting point is, of course, September 11, when we saw the attacks in the United States, and at that point Australia had not a single national statute directed specifically at the topic of terrorism. It was just not something that we had legislated for, and that perhaps seems hard to imagine given the circumstances in which we find ourselves, but that was the starting point. What Australia has done since that time is very quickly made up for time by passing a remarkable number of laws, and indeed one of the things that really is striking about Australia's response to terrorism is just how much the law has been at the forefront compared to other countries. Since September 11, just our federal parliament, not including the states and the territories, has enacted 64 separate anti-terror laws. And that far outstrips the number of any comparable country. And in fact, at particular points, it's been so frenetic that it's been almost impossible to keep up. And indeed, one of those periods was in the second half of last year, where we had a lot of foreign fighter laws. During one period when John Howard was Prime Minister, from September 11 until the fall of the Howard government in November 2007, we had 48 of those laws passed, and it averaged a new anti-terror statute going through the federal parliament every 6.7 weeks. And I'm not talking about sitting weeks, that's actual weeks of the year. So it showed every 6.5 weeks we've got a new law in this field over the space of about 6 and a bit years. What's remarkable about that is not just the sheer numbers, of course, but the comparison to other countries. And indeed, where international people have looked at Australia's experience, they've labelled it hyper legislation. Because even Americans, Canadians, the UK people and others are simply shocked at the number of laws that we have passed. And travelling internationally as I do, I'm very often asked, why has Australia done this? Why have you gone so much further in enacting laws of particular kinds even than the United States? What's special about you? Is it the threat? What is it that makes this happen? But it's undeniable that we are in a unique position internationally. But of course, it's not just the numbers, it's the scope that is most important with these laws. And give you a quick rundown of the sorts of things the laws do. They start by defining what a terrorist act is, and that's critical because everything hinges upon that question. What is a terrorist act? And it essentially involves an act of violence or even computer hacking or damage to property done for a political, religious or ideological cause that in some way is designed to coerce or intimidate government. And there's no differentiation there between what we might call historically legitimate acts of violence, such as Nelson Mandela's attack on apartheid, and more recent acts of terrorism that might be strongly rejected. There's simply no differentiation in that description whatsoever between a freedom fighter or between a terrorist. And that's indeed a real issue when we talk about citizenship stripping at the moment, because it means that if that law goes through, equally it might be applied to someone who's fighting for IS as it might be applied to someone who's fighting against IS. There's simply no differentiation in our laws as to the nature of the conflict being involved in. The offences that come off that definition are very wide. Many of them relate to committing terrorist acts, preparing for terrorist acts. The penalties are severe in going, understandably, to life imprisonment for undertaking an act of terrorism. But there's a range of other penalties. My favourite is the penalty of possessing a thing connected with terrorism, and thing is not defined. So if you think you might have a thing that is in some way connected to terrorism, that might be a document, it might be a file downloaded from the internet, that itself is a very serious criminal penalty. We've got warrantless searches whereby police can now enter your home, for example, without getting the permission of an independent judge. We've got the police being able to detain people potentially for days to question them about their possible involvement with terrorism, and Dr. Hanif was an example of that regime being used. The Attorney General, at his own volition, can ban organisations and their members can be jailed for a number of years. And the members being jailed of that organisation are not just active members, but indeed anyone who's taken steps to join the organisation, even if it turns out that they were refused. We've got preventative detention orders whereby people can be held without charge or trial for up to 14 days. And while in that form of detention, you're simply locked down in terms of your ability to communicate with the outside world, you can make a call to a family member, but the law says the only thing you can say to your family member during this 14-day period on one occasion is that I'm safe, but can't be contacted for the time being. And otherwise you disappear for that period of time. And heaven knows what the reaction would be of a spouse or a child were they to receive such a call. We've got a control order regime that again means, without any finding of guilt, that significant parts of a person's life can be restricted. The government can get an order directing that you not communicate with certain people, that you're restricted to your home, that you can't use certain technologies. In fact, any aspect of your liberty can be regulated through a control order. One of the more remarkable powers is that ASIO has the ability to have someone questioned and potentially detained for up to a week, where it's thought that that person might be able to assist ASIO with their intelligence gathering activities. So this detention regime is not directed at suspects but non-suspects. It could be a journalist, for example, who's interviewed someone of interest to ASIO. ASIO can question that journalist. If the journalist refuses to answer ASIO's question, the journalist can be jailed for 5 years. And if ASIO is concerned, for example, the journalist might destroy their notes, that journalist can be detained for a week and subjected to that coercive questioning. If another journalist wants to write a story about the detention regime, for example, to argue that it's been used against the public interest, then a journalist writing about that material can him or herself be jailed for 5 years. And it's locked down not only in terms of communication while in detention, but the ability for journalists and others to communicate what's actually happening. And this is an example of a number of laws where the burden on journalists is very large, because in terms of what a journalist can report about this regime, it's not just the fact that someone's detained, but the Act says that a journalist cannot report anything that relates to information that ASIO has or had. Now, heaven knows what information ASIO has or had. It's not defined, but it simply means that if you report anything in that category, you as a journalist can be potentially jailed for 5 years. We've got a number of new powers of electronic surveillance that apply not just to terrorist suspects, but to any person likely to communicate with a terrorist suspect. And of course, that might be the person's lawyer. And there is no protection of lawyer's privilege that means that you can communicate with your client without surveillance. Indeed, they could apply the surveillance to a priest if someone was seeking confession, for example. Those new surveillance powers have been twinned with a new metadata regime, which means that all of our electronic information is now stored for 2 years and can be accessed on a self-serve basis by police and a range of other agencies. And by self-serve, I mean they don't need a warrant, there's no external oversight of when they get the information, and they can get it whenever they think it's useful in investigating one or other of a number of offences. A warrant is in place if that information might be used to get information to identify a journalist's source, but there's no doubt in my mind that that warrant itself would be quite straightforward to get if, for example, you're simply investigating a leak or some other form of criminal conduct. The Attorney-General's been given the power to close down courtrooms from public view, and this means not only can journalists be prevented from reporting on terrorist trials, but indeed the accused and potentially their own lawyer can be excluded from the court while the court hears certain evidence relating to material that might actually lead to a conviction. And when a judge has to decide whether to exclude the accused, the judge is directed by the law to give the greatest weight to national security over other considerations, including the right to a fair trial. We've got a brand new censorship regime which enables a range of books, publications and computer games to be banned wherever they might in some way praise or advocate terrorism. And of course that might include praising Nelson Mandela. It'd be quite easy under the regime to ban his autobiography if there was any desire to do so. It's a very clear instance of something that praises, encourages, or in other ways might engage people in thinking about committing acts of terrorism, even if it's a freedom fighter. And that regime enables things to be banned, not only where it does this, but where it leads any person, perhaps to themselves, to consider undertaking an act of terrorism. And the test that the law requires is, in working out whether to ban something, it's not the reaction of a reasonable person to that publication, but also any person with a mental impairment. including someone who has a severe mental illness. And in fact, the censorship regime requires the censorship board to consider the reaction of a person with any form of mental illness to a publication. And if that person with a mental illness might consider terrorism after reading the publication, then it can be banned under the regime. We've also got, most recently, a range of laws directed at foreign fighters, of course, including life sentences for foreign fighters for fighting for IS, against IS. It's irrelevant what side you fight on. We've got new jail terms that apply just to speech, and these are reminiscent of the sedition laws of some time ago. A person can be jailed for up to 5 years merely for their speech for advocating terrorism, but that might be, for example, advocating resistance against the regime in North Korea, or advocating resistance against IS or against the Syrian regime. Again, it doesn't differentiate. We've also got a new and remarkable offence, the declared area offence, which lets the Australian government declare any point in the planet to be a no-go zone, and once declared, if you step foot in that zone, you can be jailed for 10 years. Irrespective of your intent in doing so, you can show that you were there for a legitimate purpose, but that's a very narrow category of purposes, such as visiting family members. There's no defence if you're doing business there. There's no defence if you're visiting family, visiting friends. And even if you happen to live in the area, you either must move from the area, leave your house, or you are subject to 10 years in jail. And the final one that I'll mention is that one that gives ASIO the ability to undertake special intelligence operations, which authorises them to breach Australian laws in doing so, and also says that if any person reveals any information relating to that special intelligence operation, then that person can be jailed for up to 10 years. And it means that if a journalist wrote a story saying that the ASIO operation led to the death of an Australian citizen, accidentally or inappropriately, there was corruption, there was a misuse of public power, that the journalist could potentially be jailed for 5 or 10 years for writing that story. As you can see, that's my 10-minute summary of the making of laws over 14 years. It's a remarkable list of laws, and it's a list of laws that were simply unthinkable prior to September 11. But not only are these laws on the books, but of course they're about to be expanded. And so very soon you'd have to add to this talk new offences about citizenship, and also what's been announced are also new speech-based offences directed at so-called hate preachers. Thank you.